Every Wednesday, our Justin Horn takes you inside the world of water, a natural resource that currently dominates headlines in Texas. But through many of those stories, one court case continues to pop up, and it's a case that every South Texan should be familiar with.
The Day case is the most important water case we've seen in over 100 years.
Yet it's a case that received hardly any media attention. EAA versus Day began in 1996 when Robert Burl Day, a South Texas rancher, along with others, challenged the Edwards Aquifer Authority. In 2010, it made it all the way to the Texas Supreme Court, which took 2 years to rule. The fundamental question being, do you own the water you live on top of?
The Day case answered that question and said, yes, you have that right in place.
Or simply, if you own land over an aquifer, no one can tell you you can't pump, even if it affects others who live on the aquifer.
So if you pump your neighbor dry, that's perfectly legal.
Which is where groundwater districts play into all of this. They can limit you, but they may also now have to pay you.
We know that groundwater districts can limit the amount of water that's coming out. What we no longer know is how much.
Despite this landmark case, Texas water law is still very much in its infancy, which means there's likely more court cases to come.
And according to Hardberger, Texas is the only state that currently handles groundwater this way, treating it like oil and gas, which in the end means our state's groundwater situation remains fragile.
This case really truly affects everybody who lives in Texas and wants there to be groundwater in the future.
Justin Horn, KSAT 12 News.
Hardberger says this ruling could also play a role when it comes to property owners in SAW's proposed Vista Ridge project.